I think we are.
We're live. There we are. Hello, everyone. What a day in Brussels. Even though the group here that's going to comment on the big developments in Brussels is not really in Brussels, other than Sophie, perhaps, right now. We are very much looking at kind of an exceptional development that happened today with the European Commission having introduced the Digital Omnibus proposal, which is a proposal for a regulation to amend a long list of other regulations in the digital space. Let me introduce myself, my guests, and then we'll talk about some of the key changes that are being proposed in the Omnibus with the particular focus on the GDPR. So my name is Gabriela Zanfir-Fortuna. I'm Vice President for Global Privacy at the Future of Privacy Forum. We're a global nonprofit organization. I have been following data protection for many years now and have some sort of experience in Brussels during the adoption of the GDPR. So as many of you know who are present on my LinkedIn page, I am a very close follower of the GDPR in this sense. I'm super happy to have today the opportunity to discuss some of the changes being proposed with Paul Breitbarth. Welcome, Paul.
Thank you for having me.
Absolutely a pleasure. Paul has an equally and even sort of broader experience than I have with the GDPR and the European Data Protection Law. We first met more than 10 years ago when he was a regulator for the Dutch Data Protection Authority. And now Paul is one of the most respected global experts on data protection. He's teaching at the University of Maastricht. He is also leading a popular podcast, Serious Privacy, which everybody should listen to. And has also plenty of experience as in-house counsel. So we're hoping to hear some of the operational impacts as well of what might be going on with the GDPR. And then we're also very happy to have Sophie Stalla-Bourdillon. Sophie, welcome. And
hello, thank you.
Thank you so much for joining us. Especially for Sophie, this is a bit of an exceptional context, given that she was just on a flight, and we are extremely grateful that she was able to join the conversation. Sophie is a world-renowned expert in de-identification, and she's currently the co-director of the Brussels Privacy Hub, and of course, an all-around data protection expert as well. But her chops in de-identification are extraordinary. Very long introduction, but I thought it's necessary to know where we're coming from to discuss the modifications that the European Commission is planning to do on the GDPR. So we've seen the text published only a couple of hours ago. This is the closest to a digital policymaking unboxing video that you would possibly see. So we will be exchanging ideas and kind of do a brainstorming together with you here. So please leave comments or questions. We'll be very happy to engage with them. As a big picture, we know that the community has been kind of preparing to see what happened today with the leaks of the Digital Omnibus, which happened in the past couple of weeks. So when we're discussing, we'll likely also refer to some of the differences in between the leaked documents and what we're seeing now, not only the specific changes proposed. Right, I'm done with the introduction, so let's dive in. let's look first at one of the most significant impacts that the draft amendments to the GDPR might have, and that is the definition of personal data. The definition of personal data, as was put into the GDPR, had an extraordinary impact around the world. Let me just start with that and saying that that concept that any information related to an identifiable natural person and phrased in that way has been reproduced in many laws around the world. What we're seeing now is the introduction of, or the potential introduction of a paragraph that would make the definition of personal data relative. Sophie, I will first go to you for your thoughts about the introduction of this new potential paragraph to the definition of personal data. How are you reading that?
Thank you, Gabriela. I'm reading that with some emotions, I have to say. Yeah, where should I start? So I see where the change is coming from. Of course, we've had a very important case in September that has, in some ways, trying to narrow down the definition of personal data, adopting what some call a relative approach to personal data. In my view, there are different ways of interpreting that term. So we need to be careful. The way the Commission is trying to codify the definition by trying to borrow from the case, to me, it could create some unnecessary tension, if we wanted to put it in this way, because it tends to oversimplify, I think, the test that we need for anonymization. And only focusing on the anticipated recipients, I think this is not exactly the term that is being used, but I think this is implicit in the way this is being drafted. And the means reasonably likely to be used by that particular entity can be very easily misunderstood if you don't have a full-fledged set of guidance that you could have somewhere else. For example, if you look at the work that the ICO has been doing, you will find a much more, let's say, sophisticated test to handle such questions. Of course, this is only the law, and other things need to happen. Beyond the definition, there is also the power of the Commission that seems to be now overseeing the work of the EDPB and will or may produce some more detailed guidance on that very topic. So we need to wait to see how this is going. But looking at what has already been said in various places and on LinkedIn, for example, I can see that now there is enough space then to argue and try to adopt a very narrow definition of personal data, which I think would be counterproductive and creates, problems for some practices, in particular when profiling happens and there is no direct identifier in the data, but still it's maybe problematic for the data subject.
Thank you so much for that. One detail that I noticed in the proposed added paragraph to the definition of personal data is that it does not, in fact, make a direct reference to pseudonymization or to technical measures that are put in place or to any of that technical detail that was quite important in the SRB case. There is, though, another article added. Perhaps we can discuss a bit about that on pseudonymization. But before going there, Paul, how do you see this attempt to redefine personal data in this way?
So in very many ways, because this is a very confusing provision, the way I read it. First of all, we suddenly get entity as a key definition in the GDPR. Is this also, for example, applicable if you would be in a controller-processor relationship? The definition seems to imply that could be the case. So then also the whole controller-processor relationship would suddenly be severely impacted. Do you still need your data processing agreements or not? And all of that. I think that is an interesting question that is not answered by the text of the law. The other thing is that the definition says that the entity cannot identify the natural person. It is not they shall not or they should not. No, they cannot. So based on information that they currently have, then suddenly GDPR may not apply. But then if they have other data sets and afterwards would try to re-identify, making it personal data again, what would then be the legal situation? So it's a complex definition, and I'm not sure whether the Commission has fully thought through all the consequences. From a business perspective, I would say, yay, this is good for business because the GDPR applicability and therefore compliance requirements go down. And that might be the intention of the Commission. At the same time, also for companies, this makes their world a lot more complex, because what does this mean to all their existing approaches to privacy and data protection?
Absolutely, Paul. Thank you for that. And as I was mentioning just before your intervention, the omnibus also includes a new article that's meant to provide clarity on what would be effective pseudonymization, what would be some effective mechanisms for pseudonymization. Perhaps that is a helpful addition. I think this is perhaps something that in practice controllers had been looking for. I wonder though whether it with the introduction of this new article, whether it was necessary to also think of carving slimmer, let's say, in the text of the law, the definition of personal data. Did any of you have the opportunity to peek into that new edition with the pseudonymization mechanisms?
You mean Article 41A? Is that?
Yeah.
No, yeah, I mean, to me, there was no need to change the definition. We had enough in the case law, so to be able to come up with some workable compromise, especially that we know we have some regulators working on the ground, and they had that on their work plan, and that was coming. So yeah, we need some more detailed guidance, examples of use cases in order to shed light on the practical details. Whether we will get that quickly, I don't know, and yeah, this we shall see. Obviously, the devil is in the details here. We need to see what's in there to be able to assess.
I can't say I'm a big fan of the fact that the European Commission will adopt implementing acts instead of leaving it to the supervisory authorities. And given our history, Gabriela, to adopt an opinion on a technical topic like this within 8 weeks of the European Commission presenting a draft, reaching agreement between all data protection authorities, I think is ridiculous. Either you involve them seriously and you give them the time to make their assessments and to argue points, or you don't involve them at all. But giving them 8 weeks to adopt an opinion on these kind of topics, I think is way too short.
Absolutely, and I think it's interesting you pointed out to the fact that the Commission is taking a bit more power and competence in giving guidance and implementing acts with potentially very specific requirements. I would have to note, though, that we shouldn't look at this as a done deal. Of course, this is a proposal. Of course, the European Parliament will have to weigh in, and there's the full legislative proposal where the Council will need to discuss the amendments as well and vote. So I think
reopening GDPR, so it's opening Pandora's box. This will not be done within 6 months.
That's another very, very interesting point that you're adding, Paul. I see a question from Simon Hanya, our old friend Simon Hanya. He's wondering if an organization states the data they process is non-personal, GDPR does not apply then, yes. Does that mean that supervisory authorities have no competence in such cases and their powers are non-existent? How then can such claim be challenged? I have not particularly yet seen in this proposal that an organization can state itself their personal data, their data they're processing is non-personal. But I suppose this could be a way to go about implementing such a change in the definition. Paul, perhaps do you want to weigh in on the competencies of the supervisory authority?
Well, I was just scrolling through the omnibus to see whether in the section on non-personal data, because that's also quite extensively included, there would be a provision that might solve this. But I think Simon is right. And yet again, an oversight probably by creating this new definition that indeed, if it is not personal data, then GDPR does not apply, then there is no oversight. So can you challenge the fact that somebody claims, hey, this isn't personal data? I don't know. I think that this is something for the European Parliament to solve with amendments, like quite a few other things.
Absolutely. Sophie?
No, I think, I mean, it's not enough to just allege that the data that you're processing is not personal. Otherwise, everything just breaks down. So the claim needs to be substantiated. And how do you do that? I mean, this is happening when, for example, IP addresses have been claimed to be anonymized, and that was then the end of the story. And no one was supposed then to look at all the data associated with the IP address that was supposed to be anonymized. The claim needs to be assessed. So I think supervisory authorities would still need to do their work in this case.
Thank you so much, Sophie, for that, and for also reminding me how when I first came with the gospel of the GDPR in the US 9 years ago, the biggest shift in mindset when I was talking to companies here for them was to think about an IP address as personal data, because this was something almost unconceivable to most of the companies I was talking to. And that shift in paradigm that the GDPR definition of personal data brought was very impactful. And it was truly the first thing that would kind of trigger attention after you would mention the fines, right, of the GDPR. So looking at how the concept is now potentially going to be adjusted is just, I don't know how to qualify it, fascinating, let's say fascinating.
And if I can add just one comment, which is based here on industry experience. Why is it that I'm reacting with emotions to this definition? Because on the ground, what I've seen is not so much that the definition of personal data is very far-reaching. Is that if you look at the practice, people tend to not include data into the category of personal data when it's, I'd say, obviously personal data, and they still think in terms of PII all the time without really understanding the concept of personal data. So if you just give another signal that the definition, in fact, is not that broad and is actually you can argue that it's relative, and you can also argue that you only look at the things that you can do with that data without considering potential attackers, for example, then I'm not sure this is exactly the right signal that you want to be giving.
Absolutely. Thank you for that, Sophie. I see Slavomir's comment and question on some of the changes introduced for the purposes of AI training and such. We will absolutely go to that point. So perhaps we can move from the definition of personal data adjustments and our first thoughts on that to what we're seeing in the proposal as introducing a let's say technology-specific rule or couple of rules, which is a novelty for the broader construct of the GDPR, because its main quality, in a way, is that it's technology agnostic, right? It's supposed to be technology neutral, so that this could ensure the survival of data protection principles throughout the technological revolution that we've seen starting with the first data protection laws back in the 60s and 70s. Okay, so we are seeing some specific adjustments that are made to bring clarity on how personal data can be processed, used for both development and operation of AI systems. I think that's important to mention. So it's not just for AI training, it's also for what's happening after the training. We had already seen a lot of guidelines and guidance from data protection authorities that have started to bring this clarity. So that was the process that was already happening. Now the Commission intends to make things very explicit in the text of the GDPR that, well, first of all, personal data can be processed for a legitimate interest to develop and operate AI systems under specific conditions. That's one of the targeted provisions introduced. The other provision that's targeted to this technology has to do with processing of sensitive data, which will now have at least the intention to have an exception specifically for development and operation of an AI system. Again, with some conditions attached to that, which are detailed in a separate paragraph. Sophie, what are your thoughts on these adjustments that are proposed specifically for AI training and operation?
So first, I think this version is a bit better than what we had in the leaked version, at least because of the fact that I don't think we have any new definition of special category data. So we are back to our good old definition, which is a broad definition, but I'm sure we'll find a way to make it work. I like to be optimistic. All right, so I think there is first an acknowledgement that legitimate interest may be a workable legal basis. It's a may, I think, which echo what we already had in the opinion of the EDPB. There is a bit more also on sensitive data, so special category data. We did not have that in the opinion. We've already had some data protection authorities that acknowledge that perfection does not exist with special category data. So it's probably an attempt to try to go in that direction. There are some caveats, because there is you need to have the right technical measures in place. You need to reduce as much as you can, and you also need to make sure there is also an unconditional right to object as well. So there is an attempt to look for a workable compromise. Again, here the problem is the following: AI systems are defined very broadly, so it's potentially opening the door to a subsequent amount of activities. Some of this data, special category data, is sensitive. It's the definition that we have is not even comprehending all types of sensitive data. We know that, in particular, if we compare that with, for example, US privacy law. So do we want to enforce and check what's being done? Because if we don't do that, then potentially we open the door to to some more violations of fundamental rights. So here it's a little bit playing with the fire. If we want to go into the nuance, then we also need to enforce effectively the whole body of rules that we have. Otherwise, we are going to give again the wrong signal.
Thank you, Sophie, for your thoughts here. Paul, have the DPAs been helpful so far in clarifying some of these tensions? Is any of of what's happening with the proposal targeted for AI useful?
Yes, it depends, I think, would be the honest answer here.
Yes, we are lawyers.
We are lawyers for sure, and I think both the new Article 9 sub 5 and Article 88C do have one very big advantage, and that is that they stress the need for privacy by design and privacy by default, because otherwise it will become impossible for developers and operators of AI systems to comply with these provisions. Because if you want to rely upon legitimate interest, or even if you want to rely upon consent, which can be withdrawn to train and use AI systems, there needs to be a way to also take the information out of the AI. So you need to be able to have an AI that can also unlearn information. And I don't believe that many of the large language models that we have today is able to do that. But if we look at Article 88C, it says that data subjects have an unconditional right to object to the processing of personal data. An unconditional right to object, for me, pushes towards the direct marketing kind of objection. So a hard opt-out where there is no new balancing test, where you actually are able to say, I don't want my data to be in there. Not completely clear, but that's at least what this would apply to me. I'm still reading these two provisions next to each other, but it seems that Article 88C actually offers more protections to individuals than 9.5 would do for sensitive data when it comes to objecting and getting data out of systems. 9.5 is more like, okay, well, you need to do your utmost to get the data out, whereas 88C says, no, you have a very hard right to object. And then when it comes to legitimate interest as legal basis, I understand that that is the logical legal basis. But if it's already so clear, except where explicit consent is required or where the interests are overridden by the individual's rights and freedoms, I'm not so sure if I were an AI company that I would want to rely upon a legitimate interest here, and that I could make the business case that the balancing test is right, that there is a necessity, especially the necessity when it comes to personal data. So still lots of questions, and also from a business context, not sure this is giving me any extra confidence to use personal data to train AI models.
Thank you, Paul. Thank you, Paul. I see additional comments from Simon and our very good friend Gloria Gonzalez-Fuster, Professor Gloria Gonzalez-Fuster, and their comments will be a great segue to a next important sort of batch of provisions that are being proposed. So Simon is explaining that his point earlier was that if a controller is considering they're not, I already called them a controller. If an organization is considering that they're not processing personal data, then they will not have the obligation to have transparency, to give notice, right? And to have like a policy in place on how they're processing that data. So therefore, you would not even be aware that such processing happens. And indeed, Gloria adds that in this case, you would submit an access request, wait until they say they are not processing the data, and potentially challenge that decision. I think these 2 points are very interesting because we are seeing additional interventions that the Omnibus is proposing, particularly to the rights of information and access. They are looking at some provisions to further exceptions from when notice should be given to data subjects, to individuals whose personal data are processed. which seem to be targeted to to situations where there is a pre-existing relationship between the organization and the data subject, and then there are several other conditions mentioned there. However, it is a trimming down of the right to information. But then the other very interesting proposal is about the right of access. And what's being proposed is actually a clarification under Article 12 on modalities on how you exercise your right to access. Saying that individuals who abuse the right to access with their requests for other purposes than the protection of personal data should be considered as submitting an excessive request, and the controller can not only charge a fee if they want to respond, but they can also just not respond to the right of access. I have some strong opinions about this one, but I want to perhaps go to Sophie. Have you looked at it? How are you seeing this proposed change?
So to me, any attempt to reduce the effectiveness of the right to access is a mistake, and in particular because the right to access is also leveraged. I mean, it's not only for the data subject, it's for the entire ecosystem, I would say. So just making like a data protection thing, and that's all. I'm not sure. And just think about research, data donations. How does that square with this new definition? I don't know. And if you look at the Act, if you look at the DMA, there was an effort to try to extend through portability, but portability is also access, you know. So if you give a reason, an initial reason to the data controller not to actually try to respond to an access request, then I think this is just counterproductive. So for many different reasons, I think this is not a good thing.
Thank you, Sophie. Paul, I bet you have dealt with access requests coming your way when you are in-house and have seen all sorts of various situations. Notwithstanding that, how are you looking at this proposed modification?
So yeah, I've seen access requests both as in-house counsel, but also as member of multiple supervisory authorities. I think what's behind this is what we've come to know as the weaponization of individual rights, where people, especially employees who have been, or former employees who have been laid off by a company, use the right of access to get as much evidence as possible in order to go to court and challenge their former employer, challenge their dismissal. And that is also where you come in the interplay between individual rights under data protection law and evidence collection rules, where one should prevail over the other given the situation, but may not be as useful, may not be as easy to access as an individual rights request. So I think that is what is behind this limitation that the European Commission is introducing. But I do think that if we want to do this, and I also in a business context, I can imagine that some sort of limitation here could be useful, whether I agree with it or not. But then at least we should have a clear threshold of what defines abuse, and also what defines a repetitive request. Is that every year? Is that every month? Is that every week? So also here, the text is just too vague once again. And I think one of the disadvantages of European law is that there is not an article by article explanatory memorandum with what the exact intention is of the legislator with these provisions. Just looking at the recitals is not enough to understand what is behind this, what is the intention, also what is not the intention, because well, let's use the term of the provision. Also here, the possibilities to abuse this new provision are also pretty big. So deep down, I think I'm against this provision, but I see the logic behind it.
Thank you, Paul. Absolutely. And I know that accessing your data is actually the most used right. I know that many of those requests are coming in sort of labor contexts. But I have to say this as a scholar of data protection, leaving aside my sort of current job. The right to access your own personal data is essential. And I hope Gloria is still with us. From my point of view, is part of the essence of the right to personal data protection, the fundamental right in Article 8. So any sort of limitation, you can even kind of discuss what are the limitations there that are possible. That's one aspect of it. The other aspect of it, even if we leave aside the fundamental rights, Article 8.2 dimension here, saying that you only have to exercise the right of access for the protection of personal data purposes is a bit tautologic, if you ask me, because ultimately data protection is a procedural right. Think about it as a due process type of right, in the sense of you're exercising data protection because you want to kind of ensure that all of your other rights are respected. So those could be contexts of freedom of expression, contexts of employment contexts, all sorts of other contexts, and that's why you're exercising your data protection rights, including your right to access your own personal data in a variety of contexts, just as you exercise due process when you're in a variety of contexts in the judicial system, for instance. So that would be my comment here. I also see an additional comment in the chat from Roxana Albu. She's saying that the simplifying the digital landscape, digital regulatory landscape, should actively involve citizens, patients, even, and should ensure clarity, more transparency. Crucially, liability and oversight must rest with independent institutions, providing clear safeguards and accountability rather than shifting responsibility back onto individuals. Well, thank you, Roxana, for chiming in here with this opinion. Since we're at the subject of rights, we are seeing some small adjustments, some might argue, to Article 22 GDPR, which currently is known as the right not to be subject to solely automated decision-making that has significant or legal effects, but which the European Commission intends to remove as a right and kind of assert as a normative provision related to automated decision-making, because the paragraph that's supposed to be introduced removes the wording of a right there. Other than that, it seems that the logic of it would still be a prohibition. There are some adjustments there made to the ground that it is allowed, such ADM is allowed when it's necessary for the performance of a contract, and then some additional clarifications are brought there. Any comments here? Or?
Well, if they take the right not to be subject out of this provision, how does it still belong in Chapter 3 on individual rights?
Sophie?
Yeah. No, yeah, I think, I mean, this is a prerogative, and this is a right that is going to be more and more relevant in the future, and makes GDPR attractive. So yeah, again, just like with the rights to access, I don't think it's a good idea to try to water down that prerogative and create more, I think, more confusion, because you try to touch the principle of necessity directly. Yeah, that might have repercussions for other things. I'm not convinced by this formulation.
Isn't that the overall conclusion, Sophie, that this digital omnibus creates more confusion than it provides clarity and relief for the European economy?
I mean, I could speak for hours on this topic, but I wasn't entirely convinced that actually we would solve everything through a redrafting. I think if we are serious about, as they say, innovation, then we need to focus on use cases rather than trying to redraft everything. We had a relatively good draft already, so I think we could work with that. We had some interesting case law that had different facets. We still have them, so we should be using them. And we have DPAs are learning to work together. So I think we already had like some interesting foundations to be able to work together.
Absolutely, and I'll pick up Peggy's comment to wrap up the data subjects rights portion of our conversation. My very good old friend Peggy says that the reason for the request should not matter when you're submitting an access request. The test should be whether the effort to produce the data is materially disproportionate to the data protection privacy rights of the data subject. Thank you, Peggy, for sharing this this insight. All right, we looked at the rights of the data subject. I think there is one big change that in my sort of pyramid of the most important changes being proposed is up there immediately after looking at like narrowing down potentially the scope of the GDPR entirely. And this other one has to do with the ePrivacy directive provisions, some of them being collapsed into the GDPR. So the regime that we currently have under Article 5.3 of the ePrivacy directive, but only for personal data, mind you, so not for all data under Article 5.3, but for personal data under Article 5.3, would move under the GDPR, which technically would allow for multiple lawful grounds for processing to be used when information is placed on a terminal device. Right now, Article 5.3 of the ePrivacy Directive has strict consent requirements for whenever that happens. And this created, of course, the deluge of cookie banners that we all see is particularly impactful whenever you travel from outside of Europe to Europe and then you open your devices. That's the first important change that's happening. Some purposes are introduced for which accessing information on a device will be a priori considered lawful. So there's no, it looks like there's no need for any other lawful ground to be justified whenever those four purposes will be present. And we can look at them, perhaps, Paul, if you have the omnibus open, you can potentially touch on those, what are exactly those four purposes. The other very important change is that we see another push to for a sort of a do not track type of signal, but it's not named that. It's a general privacy signal at browser level and at app level that could signal both opting in and opting out, as far as I can read in the current text, and for which the European Commission will ask standardization bodies in Europe to create a standard. Paul, I will first go to you for first reactions there.
So let's start with reaction number one, and that was why I was also scrolling through the text again while you were talking. Legitimate interest is gone. Legitimate interest was in the leaked draft as a ground for further processing. It seemed that the European Commission was heavily lobbied by the IAB to include legitimate interest as a ground for further processing, that we also see in all those cookie banners that use the transparency and consent framework. That's now gone as an explicit ground for further processing. Even more so, the updated provision now says that further processing is only allowed on the basis of consent. So that is that I think that's a win for now. We'll see what the legislative process brings. In general, I think this is probably the only way that we will be able to modernize cookie rules, because we know that the ePrivacy regulation did not make it. Putting a new proposal on the table probably will also not see any results. So this is the best chance of regulating cookies. I think, to be honest, not that much in the final text, at least, is changing, except that if it is to do with services explicitly requested by the data subject, that then cookies could come along. And of course, it's debatable what kind of cookies and trackers that would involve. And when we look at the aggregated information about the usage of an online service, also there, the question is, does that include third-party services, or would that be only first-party services that would allow for usage tracking? All in all, I think this is probably a fair balance that's been struck between the previous discussions on the ePrivacy regulation, business needs, and also data protection needs. And I said, really happy that it will still be consent-driven. Whether or not the do not track signals and global privacy consent and things like that will work, time will tell. But I think it's good that at least there is a legal foundation to force companies to respect that. One other point, which is new and which I also really like, and which helps to fight consent fatigue, is that if a user says no to consent on a cookie banner, you're not allowed to ask it again for another 6 months. Companies will not like that, but I do think for the overall user experience, that's a big gain.
Thank you, Paul. Sophie, have you had the time to see what's being proposed, or do you want to share a general perspective on the solution that the Commission found here?
So if I am not mistaken, is it the storing of personal data or getting access to personal data? The wording then is different. It's not to information. Which would be a weakening of the principle of confidentiality. And then if you link that back to the definition of personal data that is also changing, well, I don't know. And then I have so many more questions than
Yeah.
Yeah, I think as a rule of thumb, trying to just weaken the principle of confidentiality, not necessarily a good idea. Yeah, again, need to better understand exactly what are the implications here. But if that has implications for confidentiality of information, full stop, that might not be the best idea here.
Philip has a very good question here in the chat. He's asking whether this change means that personal data processed via cookies, tracking tech, will have less stricter requirements compared to non-personal data processing under the ePrivacy Directive. What will remain under Article 5.3 in the ePrivacy Directive? And that might actually be the case. We'll have to look at the wording very clearly, but my current intuition from what I quickly read is that likely this will happen. However, important to note, this is very fresh, like all of this text is very fresh, and we'll have to look with attention at all wording.
And there are still many errors in the final text as well. Lots of typos and cross-references that are not correct. So we'll have to wait for a corrected version as well.
Absolutely, my favorite typo is the one that Ioana Coca-Cola flagged right now, and I hadn't noticed it, but thank you, Yuna, for mentioning it. She's signaling that on the first page, we're amending Regulation 2016 per 1679, not 679, which in fact is a regulation that concerns fishing. For fisheries has always been the favorite sort of political policy portfolio of the European Union. So yes, I think this is indeed quite an interesting statement on the first page of this. So thank you for flagging that. I know we don't have a lot of time, but I know also that this is absolutely the beginning of the conversation. I think it's very important that we hear from the perspectives of everyone that have been sort of part of this field for the past, at least for the past 10 years, since the GDPR has taken such a prominent space in compliance programs, let's say. Before we close, there are some changes that I think it's very important to mention as well that are being proposed that will have significant simplification from my point of view effects. And I'm looking at data breach notifications. Paul, perhaps do you want to say a couple of words about that?
Yeah, this will probably be a multiple step approach, because one of the changes in the Digital Omnibus is that ENISA is being tasked with simplifying all data breach notifications, or all security breach notifications, I should say, make that into a harmonized process for all the digital laws. So not just GDPR, but also the Data Act and NIS2 and DORA and all the others. Unclear whether notification would then happen with ENISA or would still go through the national authorities. I would suggest right now the latter. Notification deadline going up to 96 hours, and only in case of high risk. So not just notifying to the individual in case of high risk, but also notifying to the authorities in case of high risk. And that is probably just because of the volume of data breaches that we've seen notified in recent years, where DPAs just do not have the resources to look at everything that comes in. From a business context, very welcome, very understandable. From an individual rights focus, probably slightly more concerning. So also here, it's looking at what is the balance, but also lots more of clarification needed from the legislator.
Thank you, Paul. One other change has to do with including a mandate for the European Data Protection Board to come up with a harmonized list of processing operations for which a data protection impact assessment is required. I think also for which data protection impact assessment is not required, and that's quite likely a welcome simplification measure as well, unless it is not. So I don't know. What do you think, Sophie?
Here we had some divergences. We're trying to bring together a special issue, and we've on the topic of simplification to try to gather some evidence. And this is a topic that has emerged as a topic where we see divergences of approach to the problem, and it would be welcome to have a uniform approach. Although when it comes to risk assessment, I mean, of course, it's always a tricky one, because it's one thing to have a template, it's another thing to make it work on the ground and make it as less subjective as possible. So I can see where this is coming from, and here there is evidence that shows that we need a more uniform approach. We need to see how that is actually being used.
Thank you, Sophie. I will now go to both of you for final thoughts. Paul, what is coming next, and is there a particular point that you want to flag, not necessarily expand on, but at least flag that we haven't touched on so far?
What is coming next is the lobby circus, and a couple of hundred, if not a couple of thousand amendments that are being pushed towards the Council and the European Parliament, just like we saw with GDPR when it was first proposed. And I think we will also see a debate on what's missing from this proposal. One of the things that I'm surprised not to see is any changes to cross-border transfers.
Thank you for that, Paul. Sophie, your turn.
This is again why the definition of personal data is very important. It's the foundation of everything. So if we play, I'm going to say dirty with that definition, then suddenly everything crumbles. So yeah, or maybe that was the intent behind it. I don't know, but it's to me it's very important to keep the big picture in mind. Otherwise we can get lost very quickly into the technicalities and don't remember anymore what it is that we are doing it for. GDPR should be the foundational layer and should remain the foundational layer, I think, at least in my world. So I will try to fight for that. The only final remarks I would like to make is maybe we are spending too much time on this tweaking and redrafting, and I'd like to see more light also on practice and things that are actually more motivating, to see whether we will be able to actually come up with a model that stands on its feet a bit more with and some of it on enforcement. I think this is going to be key, because if we allow for more reuse of data, then we need to enforce these laws. Otherwise, this is just a puppet show.
Thank you, Sophie. Thank you so much for sharing your thoughts. On my side, absolutely, I agree that how we're playing with the definition of personal data is of enormous importance, and not only for the European Union. I think this is something that should always be kept in mind, because the standard that the European Union is putting out there, is endorsing, has ripple effects around the world. If you're looking at all of the other data protection laws and regimes that have adopted and were open to look at personal data through this very broad lens, I think that's important to mention. Also, I would want to mention that the Court of Justice of the EU in SRB already found that relative approach that we've been talking about in the existing definition of personal data. So there is, this question here as well, as whether the necessity of that paragraph is warranted. Another point to highlight is that as compared to the leaks we've seen 2 weeks ago, the definition of sensitive data, of special categories of data in Article 9 has not been proposed to be modified, which is a point that I think is important to mention, because that definition would have also been narrowed down. As to what's coming next, I hope a lot of debate and discussion that matters and that is taken seriously into account by those who will work on the wording and tweak and so forth. In terms of, I see Peggy's question, anyone wants to guess a timeline? I think it's really looking in a crystal ball here. I don't know. Paul, I see you unmuted yourself.
Best guess, late 2028, early 2029, just before the next elections.
Yeah. Well, I'm very happy you had a guess there. I will not at this point offer a guess. I know that the Commission will absolutely push for this to be done quickly. But I also know that the European Parliament has already started a sort of a battle with letters sent by various political groups already after the leaks were out in the open a couple of weeks ago. So we might see a lot of back and forth there, but I don't know to what extent, because the intention of the omnibus sort of method of amending the GDPR is particularly to have it done quickly. So let's see how that will play out. Before closing, keep your eyes on the AI Act Omnibus as well, because that's another one that was published today. We will very likely have a conversation about that as well. And also, the GDPR Omnibus actually has like a very long part sort of on top of it related to the Data Act and the collapsing into the Data Act of the Data Governance Act, the Open Data Directive. So there is a lot happening there too. Thank you so much for joining us. Again, this was really an unboxing of the Omnibus. I'm so grateful to Paul and to Sophie for jumping so quickly after the documents were published to have this conversation. And I think this is just the beginning of a very intense period of debate in our little world. So thank you.
Thank you so much, Gabriela. Thank you.
Thanks
Paul.
for having us.
Thank you. Thank you.